You're trying to adjust to a new normal. The last thing in the world you want is legal headaches. So if you can eliminate the legal headaches and focus on, dealing with your own emotions that you may be going through, it's worthwhile to have the legal pieces in place. So, but with a will, most people are familiar with what it is and what it does. The next two documents on the list work hand in hand. They are the medical power of attorney and a statutory durable power of attorney. And when I say they work hand in hand, one works regarding a person's body and the other works regarding a person's money or assets. And all of us are in control of our own medical decisions and get to decide with the doctor what kind of treatment we want or don't want until the day that we can't participate in that discussion intelligently anymore, if that happens. The same thing with our money. Everybody's in charge of their own money until the day that they're suddenly not, and they don't have the ability. You'll see this with people who've been diagnosed with dementia, Alzheimer's. They may reach a point where they cannot be financially responsible anymore, and they need somebody who will be for them. So that's what these two documents do. They allow an individual to name who gets to speak to the doctor and make medical decisions for me if I can't do it myself, and who gets to make my financial decisions, have access to my bank accounts, pay my bills, sell my house, whatever it may be that's needed if I'm unable to do so. And the reason that these documents are important, again, I go back to what happens if you don't have them in place. Well, the law says that somebody has to have legal authority over your body and your money. And if you haven't named somebody officially in these documents, then the recourse, the remedy for that is to seek out guardianship. And if you've ever known somebody who's gone through a guardianship, they all tell pretty much the same story. I'll be honest with you, I'm not a guardianship attorney. It's sort of a specialized thing. I know a few though, and I've talked to them. Guardianship, cost-wise, first of all, probably starts in the neighborhood, and I say starts at about $15,000 to get in place. You could be looking at a year to a year and a half going down to the courthouse with your guardianship attorney for different presentations in front of the judge. The judge will appoint what's known as an attorney ad litem to represent the best interest of the individual that you're seeking guardianship over. And even at the end, after you go through the numerous court dates and jump through all of the hoops and you're named guardian over somebody, what you signed up for, and this is where it really gets to the people I've talked to who've gone through guardianship. They said, I didn't realize, I thought I would get guardianship and then that would be it, and I wouldn't have to go back and see the judge anymore. Quite the opposite is true. Now, if you're someone's guardian, anytime you want to move one of their dollars from this account to this account, or you want to make a medical decision, you have to call up your guardianship attorney, make an appointment, go to court, see the judge, tell the judge what you want to do, listen to testimony and evidence, and then the judge makes a ruling and says, yes, it's fine for you to do that, or no, it's not. And that continues for the remainder of the guardianship, basically for the rest of the person's life. And all this time, you're paying your guardianship attorney, you're paying for the guardian ad litem fees. It's very expensive, very time consuming, and very frustrating. So, yes, ma'am.
Keith, who needs a guardianship? Who is it that needs a guardianship?
Well, a guardianship is a remedy that is sought when a person does not have a medical power of attorney and a durable power of attorney. That was how I tied it in. It's that if you have those two documents in place, nothing in law is ever 100%, but 99.99% of the time, if you have a valid, properly crafted durable power of attorney and properly crafted medical power of attorney, then you don't have to worry about guardianship.
Okay, so there was the medical power of attorney, and then the second one
is called a statutory durable power of attorney.
Statutory durable power of attorney.
Yes.
And you would need that for the money part.
Correct. It's some people call it a financial power of attorney.
Okay. But the legal name would be statutory durable power of attorney.
Correct.
Okay, thank you.
Sure. Now, there's a couple of things that I've seen that's worth mentioning. As you might imagine, some people who come into our office have these documents that they had drafted, some at some point in the past. Some of them have gotten them from attorneys' offices. Some of them have downloaded something off the internet or one of these companies that offers a generally, general documents that are, they're supposed to be good in any state. They're not even Texas specific. I found that people who do that, you don't know what's missing in your document. And so anyway, people bring their documents to us all the time, and I tell them, I'll review them for free. I'll look at them and tell you what you have and what you don't have. And if somebody walks in and their documents are good, then I tell them they're good. You don't need to do anything. Other people, I say, do you know that your document says this, that, or the other thing? And they're shocked. Whoever prepared the document for them didn't explain to them what they had. So it's very important to know what you have and what you don't have. Quick example, just on the first 3 documents I've talked about. And this kind of goes to the people who, I'm a do-it-yourselfer. I think they know me at Lowe's and Home Depot, by at least by face, if not by name. I'm always looking to do stuff myself. But when it comes to legal documents, it's a very dangerous game to play. In Texas, for example, with a will, one single word, if it's missing, can throw everything out of whack. And I'll just share this with you. The word is the word independent. In Texas, the executor is the person in charge of carrying out the terms of the will. It's the person who gets appointed by the judge to carry it out. But Texas law requires that you name this person to be an independent executor. If you fail to put that one single word in before the word executor, then by default, the executor becomes a dependent executor. The difference is night and day. An independent executor goes in front of the judge, hopefully just one time for about 5 minutes, never has to see the judge again. They're independent from the court. The only time they'd be called back into court is if somebody accused them of wrongfully misappropriating funds or something. If you are a dependent executor, you have to go back to the judge over and over and over again with your attorney to keep the judge informed on every single step. Every time that you transfer, if the will said, give my cuckoo clock to cousin Charlie, you have to go back and tell the judge, I gave the cuckoo clock to cousin Charlie. So one word missing in a will, and it changes so much. When it comes to the powers of attorney, I see this a lot. With a medical power of attorney, I know that our firm puts a HIPAA release within the document. Some firms don't do it. I don't know why they don't do it. Some firms leave it out and do it as a separate document. We like to put it all within a medical power of attorney, so it's all in one place. Here's why that's important. If you're named as somebody's agent to make medical decisions on their behalf, when or if they cannot do so themselves, a HIPAA release allows you to see their medical records. The medical power of attorney allows you to make medical decisions. So if your medical power of attorney does not have a HIPAA release in it, then the doctor would come and say, so I need you to make this medical decision, but I can't show you the charts and the x-rays and everything else because you're not authorized to see that. So very critical that all of the component parts be there. With a durable power of attorney, they have several different types. At least we offer several different types. One is just a garden variety power of attorney. It's the kind that I would draft probably for any of you who are fully in control of your own circumstances and have all of your cognitive abilities, and you're not trying to prepare the way to get any type of government benefits like VA aid and attendance or Medicaid. we prepare a lot of those documents. When you get somebody who's more advanced in age, or maybe is suffering from the beginnings of Alzheimer's, frequently we will do what I call our enhanced durable power of attorney. It's got more bells and whistles. It gives more power to the individual who's named as the agent. Also, I'll see this frequently. People will try to get powers of attorney off the internet, and they will name one person, maybe two people, maybe one person with a backup to be the agent. And I see those, and it kind of makes me shudder a little bit, because many times people will name the first one is their first choice, and the second person is the spouse of the first person. And I'm thinking, well, that's not really very smart to do, to only have two, and they're married to each other, because married people tend to ride in cars together. And if they go through the wrong intersection at the wrong time, and both of them are, removed from this planet or injured in some way, that they couldn't be your agent, now you've got nothing. Now you're facing guardianship. So it's always wise to sit down and really think about who's in my list and how many am I going to have in succession. The odds that you'll ever get past the second person on the list is not great, but be prepared. So we've got the will and the two powers of attorney. Mm-hmm. And these are both, the will, of course, is a document that is important after a person passes away. The two powers of attorney are documents that are important while a person is still living, but maybe does not have all of their cognitive function anymore. Very crucial documents to have. The other two documents, one, just like the will, is important after a person has passed away, and that is called a disposition of bodily remains. The disposition of bodily remains allows an individual to legally name who is in charge of their body when they die. It can solve a lot of problems or that can happen when a person dies and one family member says, Mama always told me she wanted to be buried on the hill next to the oak tree up there in the family plot. And then, someone else in the family says, no, Mama always told me she wanted to be cremated and have her ashes sprinkled in the Gulf of Mexico. Well, this is a legal document that settles that problem, so that you don't have a fight. Every once in a blue moon, we'll get a phone call from somebody who probably needed one of these documents, didn't have it, and now their family's in a dispute. Somebody is about to be cremated. They usually wait and say, oh, they're going to cremate my grandfather tomorrow, and we're trying to get it stopped. Well, if you have this legal document in place, it's fairly easy to get it stopped. If you don't, then what you're trying to do is to get some type of an emergency injunction from the court to stop it, and the judge will want to see evidence of a reason why. Prove to me that grandpa said he didn't want to be cremated, and there's usually not any evidence of it. So it's an important piece of evidence that can solve that problem in a definitive way. The fifth document on the list is called a physician's directive, or directive to physicians. Some people call it a living will. I don't prefer the living will name myself, because people get it confused with a last will and testament. It is a directive that tells your doctor, look, if I'm ever on life support, mm-hmm. and I'm a vegetable, and you don't think that I'm going to come back. These days with modern medicine, they can leave you plugged in for a long time. And of course, it'll run up your hospital bill too, and probably all of your life savings, your nest egg is going to be spent paying for you to be plugged in as a vegetable, hoping for a miracle. It's a document that, again, if you imagine a scenario where an individual's been hooked up to life support and the doctor walks out into the waiting room where all the loved ones and family members are, and they say, look, I think if we unplug this individual, they're going to pass away within just a few hours. What does the family want to do? Well, The people on the left say pull the plug, the people on the right say don't pull the plug, and the people in the back say I don't want to be involved in this decision and have it weighing on my conscience. The one voice that matters the most in that moment is the individual who's laying there unconscious. So the directive to physicians gives them that voice in that crucial moment. One, it gives the doctor a little bit of comfort knowing that, look, I'm doing what my patient wanted, right? So the doctor didn't have to worry about medical malpractice lawsuits. The family, whichever the choice is, it's a lot easier for the family to accept it. They say, this is what mama wanted. This is what daddy wanted, right? So a person fills that out and signs it and makes that choice while they still have their mental function to do so. With all of these documents, anytime that I hear that there's been a diagnosis of dementia or Alzheimer's, anybody who's been to the seminars, they've got a lot of great seminars you can go listen to, or read any of the books, knows that the one thing that we know about dementia and Alzheimer's is that it's unpredictable. Everybody's case is different. Some people, it's a slow roll down a long hill, and there's almost markers, year after year, you can see it. Other people, it's a stair step where they're going along at one level, and sometimes even without a real reason, they suddenly take a big jump down. The one thing that we do know is it's irreversible so far. They're doing a lot of good research on it, but they can slow the roll in some situations. But it's not something that I've ever heard anybody say, yes, they're cured from it. And other people, of course, get diagnosed with it, and they never really progress much beyond where they started. Maybe their roll is so slow that they stay at a certain plateau. But anytime that I hear people talking about dementia and Alzheimer's, I do bring it up that there's a window of opportunity where this individual can sign legal documents. Mm-hmm. And what we see most frequently is the progression. I guess if I had to say what we've seen most, it'd be the stair step, where we will meet with a family 1 month, and a few months go by, they've said, well, we'll get back to you, we'll think about it. And the next time we hear from them is several months later, and there's been a stair step down. And so the urgency to come back and get everything done resurfaces. So there can come a point where an individual can no longer sign legal documents. There is medical incompetency, and then there's legal incompetency. The doctor decides the medical incompetency when the powers of attorney kick in, those types of things. The attorney is the one who has to decide, the attorney, and if it's a will or a disposition of remains where you need witnesses, they are the ones who decide. The individual who's sitting here about to sign this document at this table, do they know what day it is? Do they know who their family members are? Can they communicate effectively? Of course, that can change from day to day with some people. If they're vacillating in between, some people are sundowners. And so if you get them in the morning, they're great. If you get them in the afternoon, they're not. We've had, on occasion, people show up, sign legal documents, and it just was not a good day for them. And so we said, let's reschedule and bring you back another day. And they were okay that next day. The law says that an individual who signs legal documents must generally understand the nature of what they're signing, why they're signing it, and the contents of the document. Now, that doesn't mean that they have to be able to get up and give a speech about the finer points of the law that are covered in that document, but they have to generally know and approve. The law does not say, once the person has signed the document, that they have to be able to retain that information. Occasionally I'll run across people who, if you sit down and you meet with them, they've been diagnosed with some form of dementia, and you meet with them, and for 15 minutes, you can have a discussion with them just like any of us. But after 15 minutes goes by, they'll turn to you and say, what are we doing here? It's like you ran a whole lap all the way around the track, and now you have to start again. So whichever situation is applicable for a dementia patient, The only thing that I, as an attorney, can do is to say, it is possible that the window is closing. The window of opportunity is closing to get this done. Once the window closes, the remedy is guardianship, which we talked about earlier. Very expensive, very frustrating, a lot of court dates. It can be avoided. So those are the 5 documents that when people come in and say, look, I know we need to do some estate planning. I don't know what we need. I tell people, if you have those 5 documents, you're pretty well covered. 2 of them deal with an individual who is still living, but maybe doesn't have all of their cognitive function. 1 document deals with what if they're on life support, kind of right that in between, and 2 of them deal with what happens to their assets and then their body after death. So if you have those 5 documents, it covers the basics. We at our firm, we kind of bundle those up into sort of a happy meal of legal documents, if you will, and discount that because we encourage people to get all the legal documents that they need. Just for pricing sake, I can't tell you what all other attorneys charge. It depends on the firm that you go to. I usually tell people the closer you are to downtown, the more you're going to pay because the rent's higher. That may or may not be true. There are probably some younger attorneys who, rent space downtown, and generally younger attorneys also charge a little bit less because they're trying to get into the marketplace. But just for a ballpark, I can tell you what we charge. And I think that we're pretty mid-range on a lot of these things. Now, for people who've come in here and have been other places, once in a while I'll get somebody who says, yeah, I've kind of been shopping around. Well, I'm a nosy person, and I like to ask them. I said, what are the other attorneys quoting on these things? So I like to know where we are. Generally speaking, I would say that the average cost of a properly drafted last will and testament here in Central Texas would probably range somewhere between $1,200 and $1,500. Our firm charges $550 for a will. We've gone up $100 in 20 years. So I think that we're near the very bottom when it comes to the cost of that. Doesn't mean the quality is worse. It just means we want to encourage everybody to get a will. Now, the other 4 documents that come with that, if a person were to walk in and just order them a la carte, not as part of the deal, each of those would be worth $450 each. That's the powers of attorney, the disposition of remains, and the directive to physicians. So it would be theoretically possible, even though I would highly discourage this, if a person walked in on 5 successive days and said, today I want a will, next day they walk in, today I want to get a durable power of attorney, and so it's not bundled up, you could spend $2,350, I think it would come out to be, on that. Now, the good news is we bundle up our stuff to encourage everybody to get everything that they need. So we say that the will is $550, but any document, any of these 4 documents that you get with the will, we will drop the price on that from $450 to $100. So the entire will packet, instead of being $2,350, is $950, which is more than half off. But we found over the years by doing that, it's a good deal for everybody. One, it encourages people to get the legal documents that they want. It keeps the price under $1,000, and because so many of our clients go and tell their friends, we don't have to pay for advertising. So it all works out well for everybody. So so those are the 5 legal documents. Let me kind of take a quick pause here and ask, before, there's a couple of other documents I want to talk about, which are next level estate planning. But before I jump to that, does anybody have any questions about those 5 legal documents that I can answer? Sure.
We have our will and power of attorney and all that, but it's probably about 5 years old.
Mhm.
And I'm not sure that we have each one of the other four. You know,
Okay.
I know we have some of it, but I don't know about all of it. So I want to go back and open it up and look at it again and see if I can't find these 5 documents that you're saying we need to have.
Mhm.
If we don't have, if I don't see all of that, can I come to you and ask you to prepare, one of the other ones, say that I don't have?
Sure, sure.
Or look it over and tell me what it is I'm still needing?
Absolutely. Yeah, we do offer that service. I tell people, bring me the documents that you have. It'll probably take me 5 minutes because I know what I'm looking for.
Okay.
And let me explain to you what you have,
Yes.
and I'll kind of make an assessment of it. Um, I've heard one thing I do want to address, which because I heard this one time at a seminar, there was an attorney up on stage with the microphone talking. And this attorney tried to tell the crowd that, oh, you need to have your legal documents reviewed every 5 years. And I almost fell out of my chair. That's just not true. If your legal documents have been prepared properly, um, there's really no reason to have them reviewed unless your executors are moving out of town, or one of your power of attorneys dies, something. You decide that one of your kids makes you mad and you want to disinherit them. Unless something massive has changed, we've probated wills from the 1960s before. So there's not a shelf life on a properly drafted will. But yes, to answer your question, Linda, we will absolutely review them, tell you what you have and what you don't have and what the recommendations are. Now, the other piece to that is if you have a will, and I've had people say this before, they'll come in and they'll say, I've already got a will, and I look at the will and I go, yeah, it looks fine to me. But they say, we don't have the powers of attorney. So we want to get the powers of attorney. Well, here's some simple math. In order to get the deal, our attorney software is set up that if you're getting a will, you can carry that information, a lot of the information, forward to the other legal documents, and it cuts down the time. It's part of the reason why we can give the deal that we do. If a person comes in and just says, I need a durable power of attorney and a medical power of attorney and nothing else, well, those are full price. Those are $450 each. So $450 times 2 is $900. The entire will packet is $950. So why not, for $50, redo the will, get it updated, get the disposition of remains and the directive to physicians as well. So, is it possible? I mean, if somebody said, look, I've already got a will, I want to get the other 4 documents. I mean, you could pay a whole lot of money to get 4 when it'd be a lot less money to get all 5. So any other questions about these documents, Lynn?
A couple should have, each of them should have each of those documents, right?
That's correct. Yeah, back way before I was an attorney, I'm told, then this goes maybe back to the 70s or something, that for a brief amount of time, people would do what's known as a joint will, where husband and wife would both sign the same document, because they said, look, we're doing the same thing. We're saying whoever dies first, I leave it all to my spouse. And if my spouse dies before me, then divide between my kids. That's what most people put in their will. The problem is, when a person dies, their original will is filed with the county and you don't get it back. So if let's say a woman and man were married and the man died, and you go to probate this joint will, the county has that will, and that pretty much locks the woman, and she could not change her will in the future, even if she got remarried. What if she was young and she got remarried and had more kids and wanted to change? You can't, because you've already filed your will with the county. So yes, everybody needs to have their own individual documents.
I have a question.
Sure, Lynn.
Am I unmuted? Yeah. Okay. So being that we're such a cosmopolitan group over here, what if you have like an executor or executrix that is out of Texas, or the other way around? What that was actually an issue when I was the executrix for my mother, who's from Maryland.
Mhm.
So I had to transfer my responsibilities to my brother who lives in Maryland.
Right.
So what about, out of state situations?
Whenever people are setting up their wills, we encourage them to think carefully about who they're going to choose to be executors. And the things to keep in mind, proximity is one of them. Many times the first choice is simply because people almost always are choosing from their children or brothers and sisters. I mean, people in their family. Everybody knows in your close circle who you can trust and who you can't. And maybe trust is the wrong word. Who's responsible? Who's got the intellect? Who's got the drive to follow through and make sure that this happens, and who doesn't? So to me, that's the most important component part. Proximity is definitely important, though, all things being equal. If you had somebody here in town who had the ability to do it and somebody who lived on the other side of the country, you choose the local one first. But these days, ever since the pandemic hit, we've been doing Zoom court. So it's not as important that you actually be in front of the judge in person. And I think the judges like it. So this may continue in the future. Before that, I've had people before who were the executors of an estate, and they would fly in, the day before they had to go to court, and just stay in a hotel room, get up and go to court and do their thing, and then fly back. We live in 2021 where you can transfer funds online and do a lot of stuff remotely. So it's not crucial. Proximity is not as crucial as it once was. And it certainly is. You're right. We live in a society where who grows up and lives in the same town all their life anymore? It's very rare that you meet people like that. So I don't know. Did that
So
answer
it's
the question?
okay. Well, yes, halfway, but like my brother is the alternate. If my husband cannot carry out the executive's responsibilities because he's disabled and homebound, although that, he can be very able, but his pain doesn't really allow him to think as clearly sometimes. So it might be my brother who lives in Maryland. So would that be acceptable to Texas then?
Oh, sure.
You know,
Yeah.
okay,
Yeah.
so Maryland was the one that was just being kind of difficult then, I guess, because we don't have to transfer the responsibilities. They wanted somebody in Maryland to carry out those
Oh,
responsibilities.
that's odd.
Texas doesn't have that. Okay, so you did answer my question.
Yeah, Texas will allow, Texas has laws of reciprocity. Not only do they not require that your executor be a Texas resident, but they don't even require that you have a Texas will. Now, I will tell you, people who move to Austin area, we get this all the time, as you imagine. People will move from out of state and say, do I need to update my legal documents because I just moved in from out of state? And I tell them, well, Texas follows the laws of reciprocity. So if you had these documents drafted in another state, to the extent possible, Texas courts will try to honor them. However, not all states have the same requirements of their legal documents. And one example I'll give you, this a couple of years ago, we had a lady contacted our law office and said that her uncle had passed away. He was originally from New York and spent most of his life there, but the last few years of his life down here. And he had his will drafted in New York by very competent New York attorneys, according to the laws of the state of New York. He still had that same will when he passed away. Well, we were able to probate that will through the Travis County, probate court. However, there were about 5 different hoops that we had to jump through to bring his New York will up to the standards that Texas required. We had to notify all of the beneficiaries. We had to get them to sign waivers, and he had beneficiaries who were spread out across the United States. It seems like there was about a dozen of them. So we were sending out certified letters to all the beneficiaries, trying to get them to agree to sign waivers and various things. And as luck would have it, a few of them were a little hesitant to sign things. And so it took about a year, almost 2 years, to probate that will instead of 4 months. It would have been very easy had this gentleman gone to a Texas attorney and had a Texas will drawn up. We would have been in and out in 4 months tops, sometimes 3 months if the courts aren't running too packed. So
I have one more question. Do you make house calls?
do I make house calls?
Mhm.
For the most part, yes. We get, I mean, we tell people it's always preferable to meet here because we've got, big conference table, we've got witnesses and notaries and everything that we need here. But occasionally I'll get a phone call from somebody that says, look, my loved one is in an assisted living facility here in town. It's very difficult for them to move. Can you arrange for that? And I say, yeah, just if you give me just a little bit more time, we might need to plan that out a little bit further on the calendar to make sure. But yes, we've been known to make house calls.
Yeah, we appreciate it. We actually, we had ours done in 2009 and remember we're caregivers and sometimes it's very difficult at home.
Sure.
Very difficult to get a loved one out the door,
Sure.
especially if they're bedridden.
Yep.
So-
Zoom has changed the game a lot. Ever since the pandemic hit and we started doing Zoom, that's given us another tool because people know how to use Zoom. Before that, it was all FaceTime, and I don't know how many people used FaceTime. We didn't really, but nowadays, what's required is that the attorney be able to speak with the individual face to face, and Zoom accomplishes that.
Mhm.
And ask them all the right questions and be assured that the individual does have mental capacity to understand and make these types of decisions. So
I was thinking more of the signature and it needs to be
Mhm.
witnessed or notarized. And
Right.
I don't know that, so
We've-
in those instances, I mean, the lawyer
Mhm.
that we worked with back then, before I knew you,
Mhm.
is he brought whomever he needed, notary and witness and whatever.
we've done that.
Yeah.
We've done that. It's not as common. One thing that happened, I guess it was October-ish of last year. It was the first time the governor said when the pandemic hit that lawyers can do their legal documents and notarizations and witnesses by Zoom now.
Oh,
And so that was a little bit of a game changer because as long as the notary and the lawyer can see somebody sign, I've watched people sign documents over Zoom after having spoken with them over Zoom, and I know that it's them. And then they mail the documents to us after they sign them, and our notary, who watched the Zoom as well, can then notarize, yes, I witnessed this with my eyes, and then mail the documents back. So there's ways to deal with that. I would say that it's probably 5% of the time that, most of the time we meet with people in our office, but sometimes it's just not, practical. And so we'll work with folks,
yes.
try to make it happen.
Appreciate that. We truly do. Because
Sure.
like I said, I've seen other caregivers have a very difficult time transporting their loved one and
Oh, absolutely.
to get in the car or, so anyway, thank you.
Sure. So wow, have I been talking that long? It's already 11:07. So those are the 5 documents, but I always like to at least mention, there's 2 other documents that I consider to be next level. The first 5 are very basic, and I tell people everybody could benefit from having them. The second 2 documents are more specific. The first, of course, and just raise your hand if you've ever heard of something called a ladybird deed.
Mhm.
You guys have, because I've been on this. I've been on your Zoom call before, but not everybody has. A ladybird deed is one of my favorite legal documents because it allows a person to transfer ownership in real estate in their home upon death without having to go through the probate process. I think we charge $550 for a ladybird deed, just so you know. And if many people will die owning a little bit of money in the bank, maybe some investments, they've got a house, and then they've got all their personal effects. And the only real reason to go through probate in that scenario is because they own that real estate. They have to pass it on to somebody. So if a person has a ladybird deed in place, it is very possible that they can skip probate and save $3,000, $4,000, or $5,000 by having this document. The way a ladybird deed works, husband and wife who purchase a house together, not a premarital house or a house that was inherited or something. Husband and wife purchase a house together under Texas community property law. Each of the spouses owns 50% of that house, and an undivided 50%. And so when each of those spouses dies, they can leave 50% of the house to whomever they choose. For most people, it's their kids, but you don't have to. So the way that it works is you sign the ladybird deed saying, when I die, I leave my 50% ownership in this house to XYZ. And you take that deed and you file it with the county clerk's office. And then that document sits there dormant for the rest of your life. It's not an active legal document yet. It's just sitting there waiting for you to die someday. And if it's still sitting there, if you haven't revoked it or changed it or whatever else, and you die, then your loved ones, instead of having to go through the probate process to transfer ownership of the house, they simply get your copy of your death certificate. Takes about 30 days to get that. They go down to the county clerk's office to prove that you've passed away and say, we have a ladybird deed here on file. County clerk's office pulls it up on their computer, verifies everything, hits a couple of buttons, boom. The transfer has now taken place and nobody had to go in front of a judge. You saved a lot in probate fees. Very, very simple, well-worn path that not too many people are aware of. And sometimes you might hear of something called a transfer on death deed. Ladybird deeds have been around since the 70s, but they were created through what we call common law, meaning that they just appeared one day and somebody challenged them in court and the courts all upheld them and said that they're good. That's common law, as opposed to statutory law, which is where the legislators all get together and craft a bill and it goes through voting and all that kind of stuff. So our legislature liked ladybird deeds so much that in 2015, I think it was, they actually made a statutory version of a ladybird deed. It's called a transfer on death deed. So it's on the books. Some attorneys use those. Most of the attorneys I know stick with what we've used that we know works, ladybird deeds. They're time tested. They've been tested through the courts. The transfer on death deeds really haven't yet made their way through. The biggest difference that I can see between the two is this. With a transfer on death deed, only the individual who owns the real estate can sign it. Only that person. And if that person does not have all their mental capacity, then they can't sign a transfer on death deed. Ladybird deeds, however, can be signed by a person's power of attorney. So even if the person is beyond mental capacity, the power of attorney can sign a ladybird deed and effectuate the transfer, again, without the necessity of going through probate. So the other piece with ladybird deeds comes in relation to Medicaid. Medicaid is I guess I'd call it a wonderful monster. Medicaid is a wonderful monster. It does wonderful things, helping people to get the care that they need without spending their entire nest egg that they've saved all their life. When they get in the stages of life where they need 24-hour skilled nursing care. So it's wonderful, but it's also a monster. And when I call it a monster, I mean that the rules are so thick. Those of you who've met my legal assistant, VC Spears, she worked for Medicaid for 20 years and has spent the last 10 years helping people get on Medicaid. I call her the Medicaid genius, and she is. Medicaid is very difficult to navigate, even for people who've been around it, much less newbies who are trying to navigate their way through. So we do help people navigate through the Medicaid minefield. But one of the things that I tell people about Medicaid is there is something called the Medicaid Estate Recovery Program, or MERP for short. And MERP is a monster, but ladybird deeds are very important when it comes to MERP. Here's how MERP works. A person owns real estate, they own a house, and they want to qualify for Medicaid, and Medicaid lets them on Medicaid and says, we'll pay the medical bills here for the 24-hour skilled nursing care. Somewhere buried in the fine print, though, is language that people tend to overlook that says, but when your loved one dies and you go to probate their will, if you own a house, we're going to show up in court and we're going to put a lien against your house for every dollar that we paid out in Medicaid. Now, the way that this works in the real world, I talked to a friend of my in-laws who lives across the street from them, and she told me a story about one of her family members who passed away at the age of 95. This lady had 2 sons who were going to inherit her house, and her house was worth about $400,000 or something like that. But she had been on Medicaid. Nobody told her about MERP. Nobody told her about Ladybird deeds. So she died, and her will said, split my $400,000 house between my 2 sons. And it was paid off, so each son thought they were going to get $200,000. They didn't tell her about MERP. Medicaid showed up with a lien against her estate for $137,000. And the judge granted it because the judge didn't have any choice. I did hear subsequently that I think that they were able to negotiate it down a little bit, like percentage points with Medicaid, just goodness of their heart, I guess. But they lost out on $137,000 in equity because they didn't have a Ladybird deed. And the reason that a Ladybird deed defeats all of that is because Medicaid can only put that lien on a person's estate when it goes through probate. If a person has a Ladybird deed on their house, the transfer from a legal perspective happens in the blink of an eye. As soon as the person draws their last breath on this planet, the transfer happens. So the house is removed from a person's estate long before they would ever probate it. And this is the intent of our legislature. Texas is very much a person's house is their castle type of estate. It is not some, I was given a seminar one time and somebody said, well, that sounds like a pretty neat trick. I said, no, it's not a trick. It's the way that Texas law wants it to be. It's very intentional. That's why the legislature created their own version of a Ladybird deed. But most people don't know about Ladybird deeds. And so they'll get on Medicaid and they're setting themselves up for this massive lien against the equity in their house. So Ladybird deeds, one of my favorite documents. I always want to at least mention it because it can save tens, if not hundreds of thousands of dollars for people. And it's a very inexpensive legal document to have. It is required that each owner of the property, both husband and wife, have their own Ladybird deed. To answer the question from earlier that everybody needs their own will, yes, everybody needs their own Ladybird deed. And again, we charge $550 to do a Ladybird deed. So if a husband and wife both wanted a Ladybird deed, it's $1,100. The last document I want to mention briefly, when people start getting ready for Medicaid or VA benefits, both of those programs are what they call needs-based programs. They want to see on paper anyway that a person is poor before VA will start paying their aid and attendance benefits or Medicaid will pick up the tab. There is a way to shelter people's assets that is within Medicaid and VA rules. I use the word shelter specifically because sometimes people will say it's hiding money. It's not hiding money. You tell VA and Medicaid exactly what you're doing when you're doing it. I mean, there's no hiding the ball. It's all within their rules. They allow for this. VA has a 3-year look back on asset transfers. Medicaid has a 5-year look back on asset transfers. But you're allowed to create something called an irrevocable trust. And we do those. We kind of specialize in that. These are not standard. It's not a standard document you just find anywhere on the internet. It's actually specifically crafted to meet the specifications of Medicaid and VA. But if you have an irrevocable trust created, whatever assets you put into that trust, after 3 years, they're invisible to Medicaid, to VA. After 5 years, they're completely invisible to Medicaid. So let me tell you how this works in real time. Let's say that a person wants to get aid and attendance, which is money from the VA to help pay for their assisted living. And it can be somewhere between $1,200 and $2,200 a month, tax-free for life. So it's a great benefit to have for our military veterans who served in wars and their spouses. VA has a magic number that says basically if you own more than $130,000 worth of assets, you're not eligible. They're going to kick you out based upon the fact that they think you're rich, or at least you have too much money. But you can create an irrevocable trust, put the extra assets into that trust, and after 3 years, VA says that money is invisible to us. We won't count it against you anymore. Medicaid has got a 5-year look back. I could go, we have a whole presentation we do on Medicaid and trusts and everything, and VC is usually a big part of that because it's very complex. But again, it is something that we specialize in and we help a lot of folks with. But generally speaking, when faced with the prospect, modern medicine these days can keep people alive a lot longer than they used to, with the diagnostic and as well as treatment options. And so therefore, an individual could remain on 24-hour skilled nursing care, the highest level of care, a lot longer than maybe in the past. And of course, that's very expensive. Here in Central Texas, the cost of assisted living, depending upon where you go, it can be $3,500, $4,000, probably $5,000 if you got all the bells and whistles per month. The cost of 24-hour skilled nursing care jumps to between $7,000 and $9,000. I think I even heard of a place that you could pay $11,000 or $12,000 a month. I figure for that amount, they better put fresh flowers and a mint on my pillow every morning. But so just doing simple math, 24-hour skilled nursing care, if the average cost in Central Texas is around $8,000, then if a person is getting that kind of care for a year, 8 times 12 is $96,000, okay, or $100,000 for easy math. It's very common for people to come to us and they'd say, look, we've got a house that we either are selling or have just sold. And here in Austin, a $300,000 or $400,000 house is, it's a nice house, but it's not a mansion. But it's very common for people to sell for $300,000 or $400,000. And then they say, look, we've got our bank accounts and our investments, maybe a few $100,000 more. So maybe people come to us and they've got $500,000 or $600,000. And they've got a loved one who's going to need 24-hour skilled nursing. It's heading that way, or maybe they're already there. So if you do the math and you say, look, if you got $500,000 and you're spending $96,000 a year on their care, in 5 years, you're broke. Your nest egg is gone. And there's nothing for the surviving spouse. And I say surviving because we assume that this person's going to outlive the one who's needing care. It doesn't always work that way. There's not going to be anything left for the spouse who's left behind. A much better plan, we believe, is to try to shelter those assets to the extent that we can. An irrevocable trust, from the day that it's created and funded with the money that's in this nest egg, 60% of it becomes invisible to Medicaid. And what I mean, I'm going a little deeper than I intended to, but I do want to complete the thought. With Medicaid, if you went to Medicaid and said, look, my loved one needs 24-hour skilled nursing, we'd like to sign them up for Medicaid, they meet all the physical requirements, Medicaid would say, tell us about all of your assets. You say, we've got $500,000 in assets. Medicaid would say, your spouse needs to show assets of less than $2,000. Essentially, what they would be telling you is come back when you have spent out of pocket $498,000, when you spent down to 2,000. That's not a good plan at all. So what you can do instead, and I will save this for the Medicaid thing. First of all, there is a way that we can transfer the spouse who needs Medicaid. We can transfer, remember, husband and wife each own 50% of the assets. We can transfer the spouse who needs Medicaid, their 50% over to the other spouse very quickly. So now instead of 50-50, you have one spouse that owns 100% of it or 99% of it, and the other spouse legally only owns, very, very small percent, if anything at all, making them almost immediately eligible for Medicaid. Then we set up the trust and start the 5-year count, pardon me, for the second spouse, because they might need Medicaid someday too. So anyway, getting a lot deeper in that than I wanted to. I just wanted to mention the irrevocable trust. There is, among the things that we prepare, the legal documents that we do, this one is the most complex. It is the most expensive one. We charge $5,000 to do an irrevocable trust. For comparison's sake, I went to a seminar one time and there was an attorney up on stage with a microphone who said that her firm charged $15,000 for a trust. And VC tells me that she once worked for an attorney up in Dallas who charged, I think, $22,000 to do a trust. So are the trusts more expensive? Yes, but I think we're well under what a lot of people charge. And the trusts that we do are specifically crafted and drafted to meet the specifications of both VA and Medicaid. So those are things that just keep in mind. And if anybody has any questions, feel free to, usually the answers to those questions are very specific to a person and their family and their situation. So I encourage people, if you want to, I posted our contact information there on the chat. If you'd like to come in and sit down and discuss your situation, we don't charge to meet with people and talk and go over and explain all of the different options. We generally book about a week in advance. So, and we try not to book too many during the day because I never want somebody sitting in the lobby waiting while somebody else is in there. So we generally do one meeting in the morning and one in the afternoon. We're happy to meet with you, review your documents, tell you what your options are. We'll always tell you exactly what the cost of everything is. Some attorneys charge by the hour. We don't do that. It's all flat rate. We'll tell you exactly how much stuff is. Questions? Yes.
Hi.
Hi.
So this has to do with probate and not probate. If someone has a will and let's say they have all the 5 documents that you talked about.
Okay.
And they pass away, why would one choose not probating over probating?
Okay. There's no law in Texas that says that a person's estate has to be probated, whether you have a will or not. If a person has a will, the judge is not going to come knocking on your door saying, hey, when are you going to get around to probating this will? The probate of a will, a lot of it depends upon what a person owns upon their death. If they own real estate and they do not have a ladybird deed in place, they absolutely need probate, no question, because the executor of their estate is the only one who's going to have the authority legally to sign over a deed to transfer that real estate. And the state of Texas does not want there to be pieces of real estate that are in limbo. So that's the first thing. Secondly, if people have minor children, if they pass away and they have minor children, you're going to need to probate that estate because legally somebody has to have custody of those children. And it's an assessment that we make on a case-by-case basis. I've had many people come in and say, my loved one passed away, here's their will. We talk about the assets and they walk out and I tell them, I don't think you need to probate this. Sometimes, depending upon how bank accounts and investment accounts are set up. When you go to the bank to set up a bank account, they generally will ask you in some form or fashion, look, when you die, who do you want to have right of survivorship over this account? Who do you want to get the money when you die? Sometimes they'll ask it in a very simple way like that. I opened a new account for my 16-year-old who just got his first job the other day and needed a direct deposit. And they asked the question very simply, who gets right of survivorship? But different things, banks have their own different rules. What I mean by that is, for some banks, in order to claim that money that was in somebody's account, they require that you go through probate. It's their bank rule. They require what's called letters testamentary. That's the document you get at the end of probate. It's the court order. Some banks require that, some banks don't. Most people don't know to ask their banker, okay, I gave right of survivorship here to my son or daughter or whoever. Are you going to require letters testamentary? Some banks, if you ask that question, they'll say, well, the account that you just set up would require letters testamentary. If you don't want that, we can set it up a different way that wouldn't require it. So I've had people before probate a will just because the way that their loved ones set up their account at the bank, they didn't know the right questions to ask. And so they set up the type of an account that bank requires letters testamentary. Looks like everybody's muted.
I have a question,
Okay, sure, Melissa.
and this is from personal experience. What are the pros and cons of having more than one person listed as the executor? My father passed away and left all 3 daughters as executors.
Mhm.
And being in Texas, I gave up my executorship. And I will not do that when my mom passes, because from my experience, there are things that I could have helped do that I needed to help do to prod things along,
Mhm.
that I wish I hadn't given it up, because I could help transact business and get things accomplished.
Sure. What we recommend to people when they're setting up a will is to choose one followed by another in succession, followed by another. I am not a fan of co-executors at all. I think the parallel that I've made is that it's a little bit like driving a car. You could have 2 people do it simultaneously, one person doing the steering wheel and one doing the pedals, but you're asking for trouble. You're requiring 2 signatures instead of one, and you're setting up a circumstance. Now, you mentioned in your case there were 3, so I guess there would be a tiebreaker. But most people who do co-executors, it's usually because they have 2 children and they don't want to hurt anybody's feelings, so they name them as co-executors. Well, the problem is, if the executors disagree and they can't get it worked out, you've now created a situation where the court's going to have to decide, and people are going to have to pay legal fees, and you're going to have court hearings and all that. If it's just one executor, that one executor is allowed to use their best judgment. And I guess if they did something completely wrong, somebody could file a motion with the court and drag them in front of the judge and say, Your Honor, the executor is not following the will. But it's highly recommend doing one executor with several successors in a row.
Okay, thank you.
Sure.
How do you find out when a will goes into probate?
Well, it's a matter of public record. You can go online to the county clerk, whatever county it's in where the will's been filed. They should. Definitely all major counties and even some of the medium-sized counties now have their own website and search engine where you can search legal documents and wills, that have been filed. Anytime that a person is probating, the will not only becomes property of the county, but it becomes public record. And so when I mentioned trusts before, one of the reasons sometimes people will pay the extra money to get a trust is because a will is public knowledge. It is public record. Back in the old days, before the internet, that meant if somebody was nosy enough, they'd have to go down to the courthouse and request the documents or look on microfilm or whatever else. And nobody was going to do that. These days, see people, anybody sitting in their living room who knows how to do it can go pull up and see, oh, John Doe died. Let's pull up his will and see, oh, it looks like John Doe left $10,000 to his niece Sally or something, right? Well, now this person who you don't know knows that Sally got $10,000. So whether this means he's going to go, hang out outside Sally's house and look for an opportunity to break in, or whether he's a phone scammer who's going to, try to get at that money through some type of a scam. That's one of the risks that you have with the whole process of wills and probate. Now, is it really that common? No, it's not. I had a neighbor of mine who he has since passed away too, but when his wife passed away, he walked over and knocked on my door and said, "Hey, what are you doing a week from Saturday?" And I said, "I don't know why." And he said, "Well, my wife passed away, and there's a notification in the newspaper about her funeral service. And I'm concerned that while we're at the funeral, they're going to know my house is empty. They could come and break into it." I said, "You know what? I never thought about that before. I guess there are people in this world that are just that evil." So anyway, I probably got off on a side track answer to your question, but that's many times why people will, if they want to have a will in place because you don't want to not have one, then they will take the extra step and the extra costs and everything else to try to make it so that they never have to probate that will.
Are you able to see a will before somebody passes away, or is that only accessible after?
Only if that person shares it with you. I mean, you like if you were a named beneficiary and under a will for like one of your parents or something, you could ask them, "Can I see the will?" And if they said no, you don't have a legal right to demand to see the will. Because one, they can, it's personal and private, and they could change it or so.
Well, that actually brings me to another point. Did I mute myself? No. Okay. So I was just going to say, and I know all families are different. Where should you keep the will? I learned that not in a safety box in the bank where you're the only one who has a key, not there. But is it a good idea to make a copy of your will and give it to some trusted family members, or what do you think about that?
Sure. When we have people come in and sign a will, we give them the original and 2 copies. We keep a physical copy in a file, and we also keep an electronic copy. And in the medical power of attorney that we prepare for people at the same time, we also will put an indication of where they're planning to keep their original will. So this way, if an individual becomes ill to the point where somebody's needing to invoke a medical power of attorney, that means that maybe they're about to die. Instead of having people just looking, I have no idea where they kept this, they can go to the medical power of attorney and see, oh, this person said, I'm going to put it in a safe deposit box at Wells Fargo Bank on Palmer Lane. And so at least they know narrowed down where to get it. Now, not everybody has a safe deposit box. So we encourage people, if you don't have one, to go get a fireproof box. You can get those at Lowe's or Home Depot. They're about $50. They're relatively cheap. And they just look like a really thick suitcase, which is just about the right size to put documents in, and you can put it in the bottom of your closet or somewhere. It's a fireproof box. I've recommended this to people though. If you get one that has a lock on it, don't lock it. One, because that creates another situation where people say, well, I know the legal documents are in there, but we can't find the key. These things are hard to break into. Second of all, if God forbid somebody were to break into your house and come across this big, heavy, it doesn't look like a safe as much as it looks like a heavy piece of luggage, but it's if it's locked, they might pick it up and carry it away with them. If it's not locked, they'll open it up to see what's in it, say, oh, it's just a bunch of papers. There's no jewelry or valuables or cash, and they'll probably leave it behind.
Thank you.
Mhm.
Okay, any other questions from anybody? All right. Okay. Well, I guess you were very thorough, Keith. Thank you so much for sharing your time and your expertise with us.
My pleasure.
We had a lot to learn today. I took a lot of notes. So, well, I just thank you so much and wish you well. And we'll see, who else might need your services. And I'm sure we'll be in touch. Oh,
Thank-
Linda, you have a question?
I've been kind of back and forth, but I have been listening. Just poor timing today. I assume I know the answer, but if like if my husband and I come and we get all our documents prepared, I feel like our life is about to change quite a bit, quite a few times. I don't expect to be in our home more than a year, but I feel like, it's crazy not to go ahead and document it and be prepared right now. My husband's several years older than I am. I expect him to predecease me. Just different family things going on that I expect to change everything, but I assume go ahead and get it done as you stand now, and then we just come see you all the time. Or drop you a note and say, change this, do that.
Sure. Real quick, the two answers to that. The first one is back in the day when people like grew up in the same town and didn't move, they would list their house or even sometimes their cars in their will. These days people move around so much, unless there's a reason to, we don't specifically list houses and cars in the will. It falls more under a general gift, so that you can move or change cars and vehicles throughout your lifetime and not necessitate an update to your will. When people do come to us to update their will, my first question is, did we do the will that you have right now? Some people like got a will done 20 years ago with another firm in another town. They say, I just need to update my will. Should be simple. It's like, no, we have to start all over again because it's not in our computers. But once you have done a will or any legal document with us, we keep an electronic copy of it. So if you need to tweak that document, we're going to give you a massive discount on, for example, I think we charge $150 to change a document. And that's assuming that it's just normal changes. I mean, one day someone will probably walk in and say, I want to start from scratch and change everything. I'm probably going to charge them more for that. But the money really kind of just pays mostly for, we've got a big conference room that all the attorneys here fight over. And so it's to reserve the conference room, to get the witnesses, to get the notary, to do whatever needs to be done to the document. We've had people come back 3 and 4 times to change stuff. And we're certainly happy to do that. But no, you don't have to start all over again and pay, from scratch, like in the beginning.
One last question. If you had a will drawn up years ago with an ex-husband, and by years ago, 30 years ago, with an ex-husband, and you divorced, but never did anything with that will, is that will still in place, or how do you find out?
Sure. A will is valid until you revoke it or update it, and change it, which you revoke the old one when you create the new one. I think that the question that you're asking, and tell me if I'm not answering the right question, is what happens if a married couple, it's very common for husband and wife to say, if I die, leave everything to my spouse and then divide between my kids. What happens if you get a divorce and then you die? Divorce negates the name and existence of this individual in your will. So if you were married and you gave everything to your husband, and then you got divorced and then you died, the court would read your will as if his name was not in there at all. The divorce just, it is, if you haven't updated it. And I've had people come to me right after the divorce and say, wife or husband, I know that they can't legally inherit from me now that we're divorced. I just don't want their name associated with my will. So they'll change it for that, but it's not required to.
Okay.
One more question. My father, who is literally probably dying soon, has a will, and I checked it. I'm the independent executor, so that part's good. I don't think he has anything left to worry about. The only thing valuable I mean, his investments were in another company. They've been switched and now used to renovate house, all kinds of things. So he has a few dollars in Randolph Brooks just because I kept whittling and deleting all, all the mess.
Mhm.
So his will doesn't really, I mean, it really only covered his investments. And now that they're not in the same company and they're basically gone, I can't see any reason to worry about anything. I mean, I'm on his bank account as a transfer on death and a user.
Okay.
So I probably should verify that I'm okay with that, but I use it all the time. So I don't think it's going to be, and there's very minimal amount of money in it. So
Two things I would tell you to do just right off the bat.
uh-huh,
The first deals with the will. You mentioned that you're independent executor, which is great.
uh-huh.
At least this one's real easy to do. Look on the very back page of the will and see if there is a page that says self-proving affidavit.
Self-proving?
Self-proving affidavit.
Proving?
If it's an older will, not all attorneys
No,
do.
it's just a couple of years. Things just changed quickly.
Well, the self-proving affidavit may or may not be titled that. We titled the last page by that, but the language that you're looking for is basically what's required by statute so that the witnesses who signed that will don't have to appear in court. If it doesn't have a self-proving affidavit, then if you did have to probate that will, you'd have to find the witnesses and fly them in. So
They just happened to be the people at the bank that day.
okay, that can be difficult. The second thing is talk to anywhere he's got money, whether it's financial, any financial group that's holding money. Ask them the specific question. When he dies, in order for us to access his funds as beneficiaries, do you require or will you require letters testamentary? And I say it that way because again, I've seen banks call things different things. You know, they'll talk about right of survivorship and all that other kind of thing. And that means one thing to them. But the ultimate question is, are you going to require probate? Are you going to require letters testamentary? And if not, then great. Just verify that. If they are going to require it, is there a way to change while he's still living so that it doesn't require that?
Okay.
And they may, if you're trying to change those things under a power of attorney, you might run into a bank that won't let you do it because they'll say that that's self-dealing under the power of attorney.
But I mean, I can get online today and switch all his funds to my funds. I mean,
right. Well,
and we're talking minimal amount of money because I take his income every month and put it in mine anyway.
Sure. No, I understand. And the ability these days to go online with a password and transfer funds is different than having the legal authority to do it under power of attorney.
Okay.
So sometimes it's, you have both, but sometimes you don't.
Yeah, I have his power of attorney too, but anyway, I'll check with the bank.
Okay. Last thing on his durable power of attorney. If it's a standard form prepared by an attorney or even some of the online ones, usually about 2 or 3 paragraphs from the signature page, from the signature, there should be some sort of an indication whether that durable power of attorney was meant to take effect immediately or only upon his disability or incapacity. It's one or the other. It's either an immediate power of attorney or what we call a springing power of attorney. If it is a springing power of attorney that says this becomes effective only upon my disability or incapacity, then what you have is an inactive legal document that only can be activated by his doctor signing a physician's affidavit saying, we believe that this gentleman no longer has the ability to process and handle his own financial affairs. A bank who's following the law would not let you act under a power of attorney until it's activated. It's either activated because you can create it so that it takes effect immediately. It's activated as soon as he signs it, or it's activated upon getting this physician to sign the affidavit.
Commence and be in full force and effect on the date of execution hereof. Is that?
Sounds like an immediate one to me.
Yeah, I
Good.
think it has been.
Yeah.
Okay.
All right. thank
Righty,
you.
I'm sorry.
Oh, sorry. No, that's okay. I'm glad Keith was, that's why we have Keith over here, because he knows what he's talking about and he can teach us. So, but thank you again, Keith. I wanted to have a little bit of time to talk with some of the caregivers, but thank you so much for your time and for, yeah, okay, my head feels this big right now.